Zoom. Thank you, Chris. At the bottom of your screen, you will see a Zoom webinar chat box. That is where you are going to be able to type in your answers for this webinar on some of the polling questions that we have. We strongly urge you to answer them. It's just a fun, engaging way for us to understand who our audience is and to answer any questions. That's also the chat box that we'll be using for the Q&A later on in this webinar as well. All right. So I will get started. So hello, everyone. My name is Katrina Raspa, and I am a senior engineer over here at Gannett. We are the parent company of the many familiar brands in your community, such as the Cape Cod Times, the Standard Times, the Providence Journal, and so much more. I am so excited for today's webinar topic of the 6 things you need to know about your financial and estate plans. And who better to educate us on these topics other than the great Michelle Beneski and Steve Dellelo. All right, so a little bit about our speakers today. Michelle is one of the managing partners at Surprenant and Beneski, an estate planning and elder law practice serving clients in southeastern Massachusetts, Cape Cod, and the islands. And something amazing that I found out is that Michelle has been recognized multiple years from Boston Magazine for the top women's lawyers list. Michelle and the other managing partner of the firm, Dan Surprenant, are 2 of only 25 CELA attorneys practicing in Massachusetts. This distinction makes the firm of Surprenant and Beneski uniquely qualified to handle all of your estate plan needs. When you become their client, you will have a peace of mind knowing that your future, your family, and your wealth are in good hands. Now, Steve is the founder and president of Retirement Income Strategies, and for more than 30 years has been helping people confidently plan and prepare for financial futures. Retirement Income Strategies takes a holistic perspective, meaning they review all the important areas of your financial life, including investments, insurance, estate, tax, and healthcare, to create an organized and coordinated plan for your retirement. Steve is also a co-author of the book, Tax-Free Money for Long-Term Care, and a respected member of the ED Slot IRA Elite Advisor Group, an organization of financial professionals who are committed to the study and mastery of IRA planning. So let's break down the topics of discussion quickly here, and let's see how they work together. So a holistic financial planner, and what Steve is, assesses your current financial data and helps clarify investment options. They recommend cost-effective and tax-efficient strategies to help you achieve your financial goals. And they develop overall financial plans while you're living and a future legacy for your family. An estate planner ensures your assets are organized and protected during your lifetime. They plan for the what-ifs for your proper distribution upon passing. And they provide greater assurance that your wishes will be met and your estate is smoothly administered. All right, so how do they work together? Estate attorneys and financial professionals work together to create a thorough, comprehensive plan to ensure that your financial goals and estate planning wishes are accomplished the way you want them to be. All right, everyone, so we're gonna do our first polling question here. If everyone can write in the chat box, and after we just reviewed exactly what these topics are, we'd like to know, do you currently work with a financial planner or an estate planning attorney right now at this moment? And we'll leave a couple minutes for you to write in the chat box. All right, we'll wait a few more seconds. Awesome. All right, seems like we have a few mixed answers here, and this is really great to know. It seems like we're going to be able to all learn different things today in this webinar, if we are working with one or if we're not. So I'm going to transition over to Michelle now, who is going to talk about the 5 foundational estate planning documents and also just a little bit about her firm.
Hi, thank you for being here this morning. I'm Michelle Beneski. I'm an elder law and estate planning attorney, and I work a lot with financial planners. I work a lot with Steve, so I'm really grateful that he's here to give you the perspective of how we work together. I practice in New Bedford, Easton, and Hyannis, south of Boston, with my brother Dan, who is my partner, as well as we have two other wonderful attorneys, Erin Nunes and Brandon Wallaka, and a team of paralegals, because this is a very complicated topic, and we work together to make sure we're up to date and keep our expertise. Next slide, you can see Dan and I are 2 of 25 certified elder law attorneys, which is the only designation recognized by the American Bar Association. So you have tens of thousands of lawyers in Massachusetts and thousands of estate planning attorneys and elder law attorneys, but there are not many of us that have taken the time and had to have a certain level of experience in order to be deemed a specialist in this area. We've been listed as super lawyers, and Erin and Brandon are rising stars. Like Steve, I've written a book, Protect Your Family, Don't Write a Blank Check to the Nursing Home. And we're very involved in various organizations to keep our education up to date. Dan is the past president of NALA. I just found out that Brandon is going to be the president of the Massachusetts Forum for Wealth Counsel, which is an organization of estate planning attorneys, next year. And we try to be very involved in special needs planning for people with disabilities. Estate planning is not always about what happens when you die. I know a lot of people think that is what it is about, but it is both about how you protect yourself, your family, your money during your lifetime, and then after you die, you make sure that it goes to whom you want it to go to. From the estate planning point of view, there are certain documents that you need to have in place. And then you need to structure your assets in a certain way. And that's where we work with the financial advisors to make sure that what you want to happen involves more than just the legal side and more than just the financial side. They have to work together. The documents that we think everyone should have, pretty much everyone, from the time you turn 18 and you're an independent adult, are these 5 documents that are listed here. And if you go to the next slide, I'll explain what they do. Healthcare proxy. This is the document where you legally authorize someone you trust to make medical decisions for you if you can't make them for yourself. Very, very important. If you become incapacitated for whatever reason, you could get in a car accident, you could have a long-term illness like Alzheimer's or Parkinson's, anything in between, and you are not able to legally make your own decisions, medical decisions, then your family needs to go into court, believe it or not, to get that authority in order to make those decisions. And that's called a guardianship. And it's expensive, usually at least $5 grand, and it's time consuming. It could take several months, and you're sick. You want to make it easier for your family to take care of you if you can't take care of yourself, and you want to be the person that picks who that alternate decision maker is going to be. You don't want the court to pick, because they may not pick who you want. HIPAA authorization. HIPAA is a federal law that says all our medical records are private, which is fantastic, except when you want somebody to move a medical appointment or check on a test or deal with a medical bill. And they can't, because they're not you, and federal law says those people cannot talk to the other person under the law. So a HIPAA authorization says it's okay with me if you share this private medical information with the following people, and you can put whoever you want on there. I have my husband on there, for example. That way, if a medical bill comes in and he has time to deal with it, they can talk directly to him about that. Very helpful. Just because somebody's on your healthcare proxy doesn't mean they get access to your medical information, because your healthcare proxy is only good when you're incapacitated. And I hope I'm confident right now. So if I have something like a medical bill or a test that I want, my husband to get the information on for me, he wouldn't be able to do that just as my healthcare agent. But with the HIPAA authorization, he can. The advance directive is a very important document. A lot of people call it a living will, and that can be a little confusing. It outlines how you want your medical care in the future if you're not able to communicate it. So this is not a legally binding document. It's a document where you give guidance to the person who's going to be making your decisions, your healthcare agent, as well as other people like your family and your doctors, about the type of care that you want. You want life support, you don't want life support. Even further down the line, you want to be at home. You're okay with going to an assisted living. You like to be around people, things that are important to you. We want you to get down in writing so that you can have the kind of quality of life that you want in the future if you're not able to speak for yourself, as well as relieve a little of the burden that's going to be placed on that healthcare agent if you want to be taken off life support, for example. This way, they know that that's really what you want and they don't second guess you. The doctors really want you to have something like this because it makes their work with your family members a lot easier. So that's 3, and they all have to do with your physical health. The 4th document that we think everyone should have is a durable power of attorney. And this is a legal document where you name someone else, someone you trust, and we call that person your agent, to deal with your finances so they can pay your bills, manage your medical expenses, deal with insurance, investments. If you have any type of retirement account, for example, those are all individually owned. So someone else can't take out your required minimum distribution each year. Or if you need to take out extra money to pay bills, only you can do that. But by signing a durable power of attorney, you're authorizing someone else to be able to stand in your shoes and do what you can do legally, financially, things like that. If you become incapacitated and you don't have one of these documents, a durable power of attorney, then your family needs to go into court and get what's called a conservatorship of you. And that is where the court authorizes someone else to handle your finances and your legal decisions. And again, like the healthcare, it's expensive and it's time consuming. It's another $5 grand and another few months. And you don't really want all your private information out there in the court system. So by signing a power of attorney, most of the time, we can avoid the need for this. A lot of clients say, oh, I don't need that, Michelle, everything's joint. Not everything is joint. If we need to do something to protect your house, if your name's on the house with your spouse or whoever, we can't change that unless we have either a conservatorship, court order, or a power of attorney, IRAs, things like that. So those 4 documents, 4 out of the first 5, have to do with what happens if you get sick and you need a little help. I call them the just in case documents. And having them in place makes it easier for whoever you're relying on to help you should you become incapacitated, get those things done. The last document is your last will and testament. And that's the document where we distribute your property after you die. And it covers only those properties that are in your name alone. So a bank account in your name alone, a car, a house in your name alone. Your will says, where does that go after you die? And the person that you name to administer it is called your personal representative. So after you die, we take your will to the probate court, we file it, the judge appoints the personal representative, that person gathers those properties, that property, and distributes it out. But it doesn't cover things like life insurance where you name a beneficiary, retirement accounts where you name a beneficiary, jointly owned property, whether that's real estate or brokerage accounts, things like that. So those are your 5 basic documents. We think everyone should have them. I have young adult children, and when they turned 18, I had them sign a healthcare proxy, a HIPAA release, and a power of attorney, because they could be in a car accident, and I've seen this with friends, and they're in a hospital, and nobody has any authority to make their decisions because they're adults. So by having those in place, we make it so we can take care of each other, and it's really a gift that you're giving to yourself and to your family. We want you, estate plans aren't something that you just do and stick on a shelf. I know you'd like to do that, but your life changes, the law changes. And because of that, if you do an estate plan, those documents, and then you never think about it, and 15 years later you go to use it, you may find that they don't work the way you want them to, or go as smoothly as you want. And so we recommend that you review your estate plan every 3 to 5 years. And aside from the documents, we also think you need to look at your beneficiary designations, your ownership, how you own things, what kind of life insurance you have, and whether you still need it, and whether you have any trusts. Do they still accomplish the goal that you want, or do they need to be updated? And just by checking in with this once or twice, every few years, you can have that peace of mind of knowing that your estate plan is going to work when you want it to. Most law firms don't make any type of commitment to their clients. Once you're done with them, you're done. We will invite our clients back in for a free review every 3 years, just to check in. It's 30 minutes, what you did, why did you do it, does it still work? And that's a great chance to catch up on things. I also think that during these important times, you should be speaking, and your estate plan should work very closely with your financial planner, because so much of what we do won't work unless the beneficiary designations and the assets are owned a particular way, and you have certain kinds of insurances. And that's where the financial planner comes in. And I'd like to introduce Stephen Dellelo from Retirement Income Strategies. Stephen and I have known each other for a few years now, and we have several clients in common, and it's always a pleasure to work with Steve. He's very open and very knowledgeable, and I'm going to turn the rest of the presentation over to him. Welcome, Steve.
Okay, thank you, Michelle. I'm so excited to be here this morning. We've got a lot of great information to give you, and I can't wait to get started. So Michelle mentioned that we're a holistic financial planning firm. We're located right here in Easton. And what we basically do is we design customized retirement plan strategies for people who have worked hard for their money and want to enjoy a worry-free retirement. And the holistic planning process, as you've been able to conclude so far, is a holistic approach to all of the aspects of your financial world. So I'm just going to go through these very briefly and tell you some of the things we dig into. So let's start with the investments. So one of the things we want to look at is to make sure that the investments are tax efficient. You don't want to pay taxes if they're unnecessary, because unnecessary taxes paid is money that's gone forever. I can never recover that. We also want to make sure that you're not taking on more risk than you need. Most people take on more risk than is required. Remember, you're approaching or you're in retirement, and the risk level is going to be totally different. And then we want to evaluate all the holdings to make sure you don't have any laggers. You want to try to have top quartile type investments. The next thing we want to look at is insurances. Make sure you've got the right insurance for the right reason. And we want to pay particular attention to the beneficiary designations. Now, Michelle's going to talk a little bit more about this in a little more detail. This is extremely important to make sure that your beneficiaries are who you want them to be, not what you think is recorded on some piece of paper. And Michelle's going to dig into that a little bit more. And then, of course, it's the estate planning, which is what we're talking about today. It's critically important to have a properly implemented plan that's complete in all its nature. Estate planning is not just for legacy or for your heirs. It's really for while you're living, how to handle your legal affairs if you were to become incapacitated, or for a surviving spouse. The estate plan is going to be made up of two of your largest assets, which are your home and your retirement plan. So if you don't have a financial plan together, the wheels are going to come off your retirement plan, and we won't have much of an estate plan to worry about. Now, as a financial planner, I'm very interested in an estate plan for this reason. I have a selfish reason. I'm very interested in the durable power of attorney, because if I'm managing your IRA and something happens to you, you're incapacitated, and you don't have that durable power of attorney, I am not able to talk to somebody else in the family to direct the funds or make a distribution or whatever. So it's critically important to have that. Social Security is the next issue that we look at. We want to know when and how to claim Social Security so it's the most optimal payment inside your distribution plan. Now, if you're already taking Social Security, we want to look to see if we can, is it taxable? Can we make it less taxable? And then, of course, healthcare and Medicare costs in the Medigap insurance, we take care of that, we look at it. But this is where we look at the longevity risk that you would have for long-term care. 70% of you that are listening to my voice right now are going to require some sort of long-term care assistance during your lifetime, 70%. So we need to address that within the plan. And if there's nothing that could take the wheels off in an estate plan or retirement plan, talk to someone you know that is handling the financial burden of long-term care for a loved one. And then finally, we have taxes. And taxes overlays all of this. We want to pay our fair share. The IRS says that you're obligated as a U.S. citizen to pay the minimum tax, not the maximum tax. And most people, we find out, because they're not paying attention to this, are paying more taxes than they need to. In fact, I go so far to say this: if you're a U.S. citizen, paying taxes is totally voluntary. You know why? The IRS code is made up of 75,000 pages. And in those pages, there are tax favor bridges that you can take care of. That's a quick example. A husband and wife could be cash flowing maybe $40,000, $50,000 from Social Security. You could also be cash flowing 6 digits out of a Roth account. What's your tax rate? It's a round number. It's 0. So it can be done. So this is all done under the preview of being done in your best interest, which brings us to a fiduciary. I'm a certified financial fiduciary. Michelle's a fiduciary. So what is that? It's the highest legal duty to one party to another. Being a fiduciary requires us and bounds us ethically to act in another's best interest. So neither one of us have an agenda. We all have our own firms. If you came into my office, you wouldn't see the name of a mutual fund company or an insurance company on the wall. So Katrina, I think we have a poll that we want to do at this point.
Yes, absolutely, Steve. So everyone, I would love to know, this is a fun little multiple choice question here. What do you all think is the biggest risk to your retirement plan? And the 3 possible answers are taxes, medical costs, or longevity. If everyone could just write into the chat box what they think the answer is, and I'll repeat the 3 options again. Taxes, medical costs, or longevity. All right, we're getting some answers in here.
So what is our audience saying, Katrina?
It's looking like medical costs is winning here. We have 1 taxes, 1 longevity, and a few medical costs. So as we'll let a few more seconds people answer, and then Steve, we'll let you take it away and tell us what the
Okay. So let me give you my take on this. The medical answer is probably right in the long term, but the correct answer is longevity. Longevity is the biggest risk that you have to your retirement capital stack, we'll call it. And here's the reason why. The longer you live, the longer you're going to be exposed to market risk. The longer you live, the longer you're going to be exposed to paying taxes. And then, of course, the longer you live, the higher the probability that you're going to incur higher medical costs. And as I mentioned, 70% of the people listening to my voice right now will incur some sort of long-term care need during their lifetime. So when we accumulate monies for retirement, we do it all during our lifetime. We're in what was called the accumulation stage. And then when we get close to retirement, we're going to pull a certain amount of money aside to a preservation stage, and then we're going to put it into the distribution stage. This is called the money cycle. Can I go back to that last slide, Katrina, for a second?
Oh, I apologize, Steve. Go ahead.
Yeah. So we've got 3 distinctive stages. The accumulation, which you probably spend maybe 20, 30 years accumulating money. You want to take some money, put it aside for preservation, and then take it out for distribution. Now, the preservation stage, next slide, is the most important stage because it measures the 10 years prior to retirement and the 10 years after retirement. Now, why is this important? Because decisions that are made during this period could have irrevocable or long-lasting results in your retirement plan. I'll give you a quick example. My father lived till he was 94 years old. That was well beyond 10 years, way beyond his normal life expectancy. When he decided to retire, he made the decision to take Social Security at age 62. That decision of taking Social Security at 62 forced him to have a 30% reduction in his retirement cash flow, which affected his retirement lifestyle. Now, for him, that was a bad decision because he basically outlived his money. So decisions that we make inside this red zone can have lasting effect. So a lot of times what people do is they'll go from the accumulation stage directly to the distribution stage. You skip the accumulation. And what this does is it raises havoc on your tax return. And it puts your capital stack at more risk than is needed. I'll give you an example. What happened in March of this year in the market? Market went down some 35%. Now, if you were retired and you were taking money out of a retirement account that was down by 35%, the loss that you incurred can never be made up mathematically, no matter what you do to that. So this is called sequential return risk. And it's a risk that everybody has, and it's basically taking money out of an account that is deflated. So what we need to do is we need to prepare for any type of financial crisis that we have, whether it's economic, market, or health. And we happen to have a system to handle that, and it's called the bucket plan. The bucket plan is a simple way of visualizing your money, or actually setting it up so we have money in a now, soon, and a later bucket. The now bucket consists of monies that are safely put away, they're liquid, and it accommodates the next 12 months of income that you're going to need in retirement. It also accommodates that emergency fund, that comfort fund that you have to have, and any planned expenses. So in other words, I've got all of your paychecks set up over the next 12 months in a safe place where we don't have any of the market risk. Now, the next bucket we have is called the soon bucket. This is money that I'm going to need sooner rather than later. This is money I'm going to need over the what? The next 10 years. The next 10 years. This money is invested conservatively with an accent to its income and an inflation hedge. Again, it's invested conservatively, so I don't have to worry about the money, the market taking a hissy fit like it always does. So with our clients, when the market went down 35% in March, it didn't matter. Because why? I didn't have to touch that money until the later bucket. And the later bucket is money that's long-term, geared for growth, legacy planning, and for inheritance. This is where your long-term care planning would come in. So when we think about our retirement capital stack, we've got these three different cylinders, if you will, or three different buckets to put the money in. Now, the way we put the money in, we use a thing called the tax-efficient funneling system. Next slide. The tax-efficient funneling system breaks your money up into the three flavors, I'll call them. All of the money that you have in your world can be categorized in one of these three categories. Number one is pre-tax money. You know this money is the money that's in your IRA, 403B, 401k. You're putting money in pre-tax, it's growing tax deferred, and you're going to pay taxes later on when you take the money out. The next bucket of money we have is post-tax money. That's the money that you have for your bank account, real estate, brokerage account, and you're going to pay taxes as you go along and as you sell that. Now, here's the distinction between these two buckets of money. In the pre-tax, you're paying an income tax rate. So let's say you're in a 22% tax bracket. Every dollar that comes out of your IRA, 22 cents is going to go away. Where in the post-tax, you're taxed at a capital gains rate. And for most people that are on this call, your capital gains rate is 15%. Now, with the new tax law that went through in 2017, we know there's a third tax capital gains rate, and that's zero. How do I get that? By having my taxable income, not my lifestyle income, my taxable income, and a 12% tax rate. Oh, wait a minute. Now, if I know that, I can structure the bucket plans in such a way so I can take money out of my post-tax and not pay any capital gains. The third bucket is the tax advantage. This is my favorite one. This is where you're putting money in after tax, it's growing tax deferred, and guess what? It comes out tax-free. These are things like Roth IRAs, cash valued life insurance. This is why we look at the life insurance, because permanent life insurance has got some very unique tax favored bridges attached to it. Your health savings account. So we use those funnels to fill the three particular the bucket plans, buckets that we have for the bucket plan. And then we'll evaluate your retirement plan for ever changing environment. Now, I'm going to talk about the, Michelle's going to talk about the beneficiary assignments and how important this is and how it dovetails with our retirement plan. So Michelle?
Thank you. That was really interesting, Steve. And yeah, retirement plans, as you know, have beneficiaries on them. Usually when you start an IRA or some kind of account, life insurance, you name who you want to receive that at your death. But life changes, and I've seen this in my practice where those beneficiary designations may not have changed. For example, you may have left your life insurance to your spouse, but then your spouse died and you never changed it over to your children or someone else. And when that happens, and then you subsequently die, unfortunately, the payment is going to go according to the beneficiary designation. It doesn't matter what your will says. It's going to whoever is named on that beneficiary form, and you may no longer want it to go to that person. Perhaps it's your ex-spouse and you left the life insurance to them. They're getting it, not your new spouse. So it's really important that you check your beneficiary designations on a regular basis to make sure that they're updated. You also want to make sure that the contact information gets updated, because otherwise there could be a delay in them receiving those that information. And if you leave certain accounts to someone who's deceased, it can have some very negative income tax consequences. It could cause a IRA to become immediately taxable. So you really want to make sure that those stay up to date and that they are who you want to receive them and in the right way. They're filled out. I have also experienced that some of the financial companies over the last 20 years have consolidated and changed, and your designations that you may have made in the past somehow got lost in the filter, and that's not good. So it's important to check in, even if you think you've done it, and make sure that it will work the way you want it to when you pass. And beneficiary designations supersede any kind of will or trust designation. So you can name your estate the beneficiary, and then it's going to go through your will, but that's often not a good idea. So each year you should meet with your financial planner to go over those designations and make sure that they are where you want them to be. You should look at your retirement accounts, your brokerage accounts, your life insurance policies, and your bank accounts, because a lot of people don't realize you can name beneficiaries on your bank accounts in order to avoid probate. And in a lot of situations, that's a very simple way to avoid the probate process and transfer your assets quickly and easily, but it's not for everyone. You can establish peace of mind that knowing that things are going to work the way that you want them to. Next slide. We're going to talk about two new laws that have come up over the last year, and I'm actually going to turn it over to Steve to talk about the CARES Act. And the CARES Act is an act that was passed in relation to the coronavirus, and then I'm going to speak a little bit more about the Secures Act. So Steve, can you talk about the CARES Act, please?
Sure. Thanks a lot, Michelle. Hey, before we get to the CARES Act, I have to tell our audience about this one particular story that we had. that has to do with beneficiary designations and how important it is. When she had that last point about the Supreme Court in 2018, it doesn't matter what your will or trust says, it matters what the beneficiary designation is. So here's the story. A husband and wife, was a second marriage for both of them. They went to Michelle, they had her estate plan put together. When Michelle did the audit on the insurance, stop me if you've heard this story before, the husband had his ex-wife as the beneficiary on the insurance policy. Fortunately, Michelle caught it. We changed it. And unfortunately for him, about a year later, he did pass away. But you can imagine the havoc that would have caused within the family. So I can't stress it enough. In our office, it's an annual routine. Okay, so the CARES Act was one of three major tax reforms that we've had over the last 3 years. Now, when these tax reforms go through, we've seen some good out of these and we've seen some bad. And this is what I'm going to tell our audience. Just because Congress says that you can do something does not necessarily mean you should do it. So we pulled out three highlights in the CARES Act that was passed this past March. The first thing was you can double the amount that you can take out as a loan in your 401k. So right now the amount is $50,000 and you could take up to $100,000. It's nice to have this available, but this is not something that we would support. After all, the 401k is your retirement money. It's not your private bank. And if you're dipping into the 401k for loans, then maybe we should sit down and have a different type of discussion. The second thing is they've allowed savers to take an early hardship distribution of up to $100,000 from either a 401k or an IRA and waive the 10% penalty if you're under 59 and a half. Because the way the rule is, if you touch those retirement monies, I always tell my clients that they say, well, Steve, how much money should I put in that 401k? Whatever you can afford, because you can't touch that money. That money is held hostage until you're 59 and a half. If you touch it, it's a 10% penalty. Well, life goes on, and sometimes you have to do what you have to do, and you may have to dip in to take care of an emergency. So they've allowed you to put $100,000, you can take $100,000 out and they'll waive the 10% penalty. Now, the tax is still due. You got to pay the tax. And there's also a provision in there that lets you put it back into the 401k over the next 3 years. That, again, a feature, I don't know if I'd really want to do that because, and we'll get to that in the final point. The final one is that it's allowing retirees, whoops, we lost that slide, I think. We want
So sorry, guys. I'm so sorry. Keep going.
let me know when we have that slide back.
Sharing it right now. Today's technology and Wi-Fi, depending on this.
So you see, this is the new reality that we have. I have to.
Yes, it is. There you go. I'm so
I
sorry.
have to stand here for 30 minutes and talk to a plastic box. I can't see the 21 people that we have here. All right. So the final point is it allows the retirees and those who have inherited IRAs to skip the required minimum distribution for 2020. Let's talk about this for a minute. So if you are a person that's got to take a required minimum distribution, you can skip it this year. And what Congress is saying, hey, we're going to give you the break. You don't have to pay those taxes. This, again, is a provision that is kind of in the middle of the road. It's not something that we would endorse. And I'm going to tell you why. If you think the taxes are going to be greater in the future than they are today, here's how I want you to think about this. If your required minimum distribution was $1,000 for 2020, and you skip it, you don't take it, I want you to think of that $1,000 as going to the back of the line. That's now going to be the last $1,000 you're going to take out of your retirement account. My question to you is this: do you think that $1,000 is going to be taxed at a higher rate or not? Sure it is. So we always want to take advantage of the IRA. Now here's a strategy I'm going to give you. Instead of taking the money out and coding it as an IRA, as a required minimum distribution, code it as a distribution. And then you can take that distribution and convert it over to your Roth. Very clever, because we know that RMDs cannot be put into a Roth. But if it's not an RMD and it's just coded as a distribution, you can put it into the Roth and it's tax-free forever. Just another little trick or tax favor bridges in that 75,000 pages. So I'm going to turn it back over to Michelle, I believe. And
Yes.
there we go.
Thanks, Steve. I think that's very valuable information. I know when I sit with my clients, one thing is they don't feel the need sometimes to take out that RMD. And so I know a lot of them are happy this year that they don't have to take it out, but I don't know necessarily that they're thinking about the fact that eventually it's going to come out and they might have to pay more taxes than they would have if they took it out this year. And maybe there are other things they can do, like convert it into Roth money. I hadn't thought about that, so thank you for that. Because I hear it from them. Why do I don't need this money right now. I don't want to take it out. And so they're all happy this year that they don't have to take it out.
Yep.
Another act that passed, and it's almost a year ago now, but it feels in some ways like it was yesterday, is the Secure Act, setting every community up for retirement enhancement. Congress has a way of getting their acronyms in. This law was really a surprise to me. I know that they had been considering these kind of changes for a long time, but they sort of like left it on the back burner for 2 or 3 years and then overnight passed this law. And it makes changes to how retirement assets are treated in certain ways. It makes it easier for small business owners to set up safe harbor retirement plans that are less expensive and easier to administer. It allows part-time employees to become eligible for employer retirement plans. In the past, a lot of times you had to be full-time for at least a year before you could enroll and start saving for your retirement. So I guess Congress wants us to start saving for our retirement and trying to make it easier. I have no idea if it actually does, because I don't set those up. The Secure Act also pushes the traditional age that you had to start taking those required minimum distributions back from age 70 and a half to age 72. And for a lot of folks, that means changing their financial plan. And I sent them back to see their financial advisor because they may want to do that, or they may have a plan that's setting up income for the rest of their life based on 70 and a half. So it's a change that in some ways is good, but it could also be bad. You really need to evaluate that with your financial planner, but you no longer have to start those distributions at 70 and a half. The change that I've noticed the most impacting my clients is not them, it's their children. The Secure Act now mandates that if you're taking an IRA distribution, you used to be able to take it out over the children's lifetime. And now all the distributions, all the money has to come out of that inherited IRA over 10 years. And that has a lot of consequences, income tax consequences and asset protection consequences to the children who are receiving, or the family members who are receiving an IRA in the future. Not your spouse, but any non-spousal beneficiaries now have to take that money out a lot faster. That can make a big difference. And the Secure Act also allows 401k plans to offer annuities. I guess this is something they couldn't do before, and that's more on your side of things, and it gives them an additional investment option. Again, it's one of those things where it could be good, it could be bad. It's something you need to discuss with your financial advisor. So that's the Secure Act, and if you have, as a lot of my clients do, a significant amount of your wealth in retirement assets, it's something that you need to be aware of, and you should discuss with both your financial advisor and with your estate planning attorney, because it can affect your estate plan, since that's one of the largest assets you have in your estate plan. We're going to be talking about how it can impact you more at another webinar that we're having, Steve and I, in October. And you've got the information there, Thursday, October 1st, 2020. We have 2 sessions, and I hope you'll join us then.
Thank you, Michelle. Yes, very excited about the upcoming webinar of the Secure Act. And I do apologize, everyone, for the Wi-Fi mess up there. But now we are going to be going into a Q&A. And I actually, Steve and Michelle, already see some questions in the Q&A section of our Zoom. So I'm going to ask the first one to Steve from Nelson. It is, what is the purpose of insurance if your prepaid cost of death now, and also what is a fair rate for taxes a retired person income should pay? Thank you.
Okay, so the first part of the question is, what's the purpose of the life insurance?
What is the purpose of insurance if you prepaid cost of death now? I'm sure that might have been a little bit of a typo there.
Yeah, okay, so you got a prepaid final expense. So the life insurance can do a couple of things. It can act as a depository to receive some of those RMDs that you may not be using, or money that you have at the bottom of your IRA stack that is not going to be used during your lifetime. When you have permanent life insurance, your 60s and 70s, you can also get a long-term care benefit. So it really does three things for us. It accumulates cash that you have access to. It gives you legacy planning so that you get you put this amount of money in the life insurance and you get this amount of death benefit to your beneficiaries. You don't have to mess around with an inherited IRA. And then if you get sick, you have long-term care protection. And what was the second part of the question again?
The second part was, what is a fair rate for taxes a retired person income should pay?
What's the tax rate a retired person should pay?
Should pay, yeah.
The lowest. Okay. Your tax bracket can actually be engineered, and that's where those tax efficient funnels come in. So we really want to try to get you into a 12% tax bracket because that's the most tax efficient, and we end up with that zero estate tax. And you also get you minimize your Medicare premium. So you got to be careful of what we accountants call bracket creep. You'll creep up into the bracket. So hopefully I answered that. But
awesome. And then Michelle, on naming a beneficiary on accounts, can you name a trust account and have the trust make the distribution?
Sure, so that's a good question. Yes, if you have a trust in existence, say a revocable living trust or an irrevocable trust, you can name it as the beneficiary of an account, and when you die, it will transfer automatically into that account. So there's no probate. Once it's in the trust account, the trust takes over as to who gets that money, when and where. For single people, that works well because it avoids probate and it provides privacy and in your distributions. For a married couple, if the trust is named as the beneficiary of your accounts, you may lose some estate tax minimization provisions. Estate tax minimization opportunities, I would say, that you may need. And so whether that's a good idea if you're a married couple, it would really depend on your own financial position.
Gotcha. And I do see, and if anyone has any other questions, you can certainly write them in the chat box in your Zoom webinar account. I do see another one. It may not be a question, but maybe would be a good answer for the both of you. Is somebody had wrote, I have a trust fund, but I do not work with anyone other than a lawyer. So maybe Steve, do you think that that's something where also using a financial planner would be smart?
Yeah, if the funds are inside the trust, think of the trust as a garage and you're just parking the investments in there. He says he's working with what, an attorney?
Yes.
Okay.
To create the trust, but not, I doubt the attorney directs the investment.
Yeah, so you need someone who's licensed with the federal government to execute the necessary trades and populate that trust with the proper investments. And this is where we find that most people still have the same risk tolerance in that portfolio that they had during the accumulation stage. In fact, they should be toning it down. They try to reach for market returns when they should only be reaching the returns that are necessary for the bucket plan to be executed. In other words, performance reporting is irrelevant when you're retired. It's only relevant to the later bucket. So the planner adds some value to the table because they're able to do things that the attorney may not be licensed to.
Gotcha. All right, another question just came in. Any special considerations for military or federal civil service pensions?
I can think of a couple. It's not necessarily on the pension side and what you're receiving for your pension, but depending on when and where you served in the military, it can impact the type of health care that you can access, and it can also impact the type of planning that we do related to protecting assets from long-term care costs. And that really, again, varies from service member to service member and where and when you served and a few other things like that. I can't think of anything special for federal civil service pensions.
The thing I would add is the pension is always a wonderful thing to have. And we have a lot of clients that have the federal pension. Here's what I'll tell you about this. That money is going to sit on that tax return, and it's coming to you. We call it mailbox money. The downside to this is that in almost all cases, your Social Security is going to be taxed, and there's not a whole lot we can do for it. But you know what? I'll pay the tax on the Social Security. It's the penalty for success. God bless you. You've got the pension. I'll take the pension any day of the week, and I'll gladly pay the taxes on the Social Security.
Fantastic. Well, it doesn't look like there's any more questions coming in. And for the sake of time, I'm just going to lastly say, if anyone is interested in starting a holistic financial plan and achieving those important long-term goals that Steve had mentioned, please reach out to him and his team for a complimentary right fit call. And Steve, I'll let you talk a little bit about your bucket.
Yeah, so this book was, if I get on the camera, was written by my good friend, Jason Smith. He's part of our mastermind group. I wrote the foreword. It's been on the bestseller list for Amazon and Yahoo. It's a true story of two of Jason's clients, and he takes them through the bucket plan process. It's an easy read. You get that through it in an evening, and it tells you the details and the mechanics of how that bucket plan works. It's probably the quintessential book, the only book you're going to really need for retirement planning. It just takes the mystery and the confusion out of retirement income planning and puts it into a picture form, because after all, we're a visual society. So if you give us a buzz and book what I call a right fit call with us, we'll gladly ship out the book to you. Okay?
Amazing. Thank you. And for Michelle, if you guys are ready to secure your future, please contact her office at Surprenant Beneski, and you will certainly all have a peace of mind knowing that your future, your family, and your wealth are in good hands. So everyone, thank you all for joining us today. And thank you so much, Steve and Michelle. Everything that you gave us today was so insightful. And I hope that everyone is safe and that you guys all have a great day. Thank you so much.
Thank you.
Okay. Have a good day.